Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Thank you very much. Welcome to the Appeals Court. We are meeting self-evidently by video conference rather than in person in light of the pandemic. However, our argument rules remain the same as they are in the courtroom, which is to say 15 minutes per side and no rebuttal. I am lucky, and you are lucky, that I'm joined today by Justices Wolohojian and Sachs. And we are hearing one case this morning. It's number 19-893. Nannucci versus Hynds, and we will hear first from Attorney Lombardi.
Thank you, Your Honors. Good morning. May it please the court. Michael Lombardi representing the appellants Stephen and Joyce Hynds. Adverse possession case. The parties are married couples who live next to each other in the Auburndale section of Newton. My clients, the Hynds, also own a 5,000 square foot parcel of raw land that separates their two respective residential structures. The Nannuccis have, the court awarded the Nannuccis a 500 square foot strip of that 5,000 square foot parcel of land. The land is a perfect rectangle, 100 feet by 50 feet, and the Nannuccis received, by way of this action, a strip that was 100 feet by 5 feet. That's not what they sought. They sought approximately 800 square feet of land, including 3 trees that my clients removed on their property, and for which the Nannuccis claimed $27,000 in compensatory damages for the loss of those trees. The trial court did not award any damages for the trees and found the disputed area to be closer to the Nannucci's residence and away from the trees. In any event, a couple of salient points I'd like to bring to the court's attention. This matter was tried on March 1st and 2nd, 2016. And despite repeated inquiries from my clients, I couldn't really answer them accurately as to why it took 3 years to get a decision out of the land court on this particular matter. The amended decision was issued by the land court on April 10th of 2019. During the course of the trial, the defendant's case was reached on day 1 of that trial. And at the commencement of the defendant's case, I raised the issue of an obscure limitation statute, General Law, Chapter 260, Section 28, which admittedly I had not come across at the time that we answered the complaint and filed our corresponding counterclaim. Did a little bit of homework on this particular statute, find that it's been around for a while, 1836 anyway. It derives from the common law that preceded the War of 1812. It has no appellate precedent treatment in the Commonwealth of Massachusetts. So we have a matter of first impression. The trial judge allowed Attorney Starkey and I to fully brief the matter and argue the validity of the statute, or the invalidity as the case may be from my brother's perspective, 6 months after the trial on September 20th of 2016. So my interpretation of the statute, I was just reading the trial, rereading the trial judge's interpretation of 260 Section 28, and I'm just as befuddled as when I first read the decision a year and a half ago.
Mr. Lombardi, may I ask, and I'm looking at footnote 19 of the trial judge's decision, which I think may contain the core of his analysis. I'm wondering, what do you think is wrong or erroneous about the judge's interpretation that the statute would give the Nannucci's possession if they didn't just merely make an entry thereon, but continue in open and peaceable possession of the land for 1 year next after such entry?
Well, it certainly doesn't give them a cause of action for adverse possession, having been on the land.
No, they'd have to be there for 20 years or more than 20 years for that cause. But at least for purposes of this statute, assuming that the Nannucci's are the no person referred to in the very first clause, it seemed to the judge, and I'm wondering what you think is wrong with this, that they not only made an entry thereon, whether it was in the early 50s to put up a chicken wire fence or sometime in the early 90s to put up a wooden fence, but they continued in open and peaceable possession thereof for at least 1 year, and in fact, 20 years, according to the judge's findings. What's wrong with that logic?
Well, just looking at the statutory construction here, it's disjunctive, or unless an action has been commenced upon such entry and season within 1 year. So our reliance is on the very last component of the statute itself.
But it says or. So let's assume you're right, although I'm not. I don't think this is really a statute of limitations. It's some definition of who's in possession. But still, let's say you're right, and they didn't meet that second part about a year from season and so on. It says or right before it, and the thing before it is after entry staying on the land for a year, and they've been on the land for a lot more than a year. Why doesn't that, whatever this is, even if it's a statute of limitations, why doesn't that half of it render the rest irrelevant?
Well, there's I know we're talking about a tacking case here. Clearly, the Nannucci's were not themselves in possession of this property for a year. In fact, when their predecessors in title were had the survey brought to the attention, the Nannucci's actually had equitable title pursuant to their being signatory buyers to a purchase and sale agreement. So they hadn't even taken full title, to this property at this time. But I think it may be helpful to posit a hypothetical that what if, assuming, arguendo that somebody is in adverse possession for the requisite 20-year period or more. And I don't know if we've ever experienced anything like this, but it may well have happened. And they abandon the land, and the record owner wakes up and repossesses the land and builds a house on that land. Does the previous adverse possessor still have a claim? He didn't bring an action to quiet title, to try title, and I would submit that Section 28 is somewhat analogous to a rule against perpetuities in that it obligates an adverse possessor to take affirmative action, to bring a civil action, to become the successor record owner of the property, so that our system of registration and so forth will allow prospective buyers and holders in due course to have that information.
May I ask you a question? There's part of your argument that is, I'm not sure I follow. When you read the disjunctive or in the statute, I understand you to be saying that your argument here rests upon the second, what follows the word or. Is that correct?
Yes.
Why is it that it can't be satisfied, though, by what precedes the or? In other words, I don't understand why, if they can't satisfy one, they couldn't satisfy the other.
Well, I would submit, it's a fair question, and my interpretation, since I first laid eyes on this, and I've certainly bounced it off of some of my colleagues, and none of them have taxed me with questions such as your honors have. But unless he has continued an open and peaceable possession thereof for 1 year.
Right. So assuming that tacking applies, let's say that the concept of tacking applies in this, for purposes of this statute, just as it would for adverse possession, then
Right.
therefore the he would be not only, the current
Owner, but the
person,
predecessor.
the current person, but also the predecessors who qualify for tacking. So
Yeah.
why, if we have something that's in the disjunctive, why can't we look at the first clause? How is it that they wouldn't satisfy it here?
Well, it's they appear to, considering the tacking, they appear to have satisfied the first half of the statute. Because
and if
it's
that's the case, so then how is it? So then what do we need to decide what the second part means? For this case, maybe
Yes.
future case.
Yeah. I do. I would submit that because of the entry by my clients and the Nannucci's and predecessors having been dispossessed, that they were compelled. Otherwise, this language is toothless. They were compelled to bring an action by April of 2013, or at the latest October of 2013.
Okay, but if you're, and so what I sort of hear you arguing is that in lieu of it being or in the disjunctive, we should read it to be and in the conjunctive, that they would need to satisfy both things.
Yes. Well, in effect, yes.
That helps clear
Yes.
things up for me. Thank you.
Yes. I mean, the only reason that my initial interpretation was other is because there has to be a disseason in order for the preposition to be construed as and in order for it to apply as such.
Mr. Lombardi, unless you have more to say about Section 28, I want to shift to your challenge to the merits of the judge's decision based on the facts. Assuming that we were to find no error in the judge's finding that the wooden fence had been there for at least 20 years, what element of adverse possession is missing?
The consistency, there are 5. If you were to find that, Your Honor, you would have to set aside the fact that there are 5 witnesses cognizant with.
Well, I'm not saying we're going to.
Right.
I'm not saying that we've reached any decision about whether the judge's finding in that regard was clearly erroneous or not.
Right.
But assuming, for purposes of argument, that we don't find don't see a flaw in that particular factual finding, what element of adverse possession is missing here?
Well, one component is permission. Mr. Joseph Papa was.
There was permission. claimed permission with regard to the chicken wire fence and Kenny McLeod?
Yes, permission was granted to Kenny McLeod to build a garden bed.
Yes, but that was
but that was
chicken wire.
established.
That was the chicken wire fence, correct? Many years before the wooden fence was erected.
Yes, the chicken wire fence was authorized by the Hynds predecessor entitled Joseph Papa to corral the McLeod's dogs. And that permission has no treatment in the trial judge's decision.
Doesn't the judge find it was without permission? I think the judge says that. I may be mistaken. Without any discussion really of it, but I think the opinion says without permission.
I don't recall that. I know that the testimony of Mr. Papa's daughter, Virginia Gardner, who was the executrix of his estate at the time and the seller of the property, testified contra.
Yeah. Your time is expired. We'll ask your brother about this as well. Are there any further questions? Thank you very much. Excellent argument. We'll hear now
Thank you.
from Mr. Starkey.
May it please the court, members of the panel, good morning. I'm Hugh Starkey for the plaintiffs' appellees, Peter and April Nannucci. I'd like to start with the findings of fact. The appellant's brief, the Hynds' brief, reads like a post-trial brief. It tries to stitch together a new set of a pattern of favorable facts. Doesn't really address the facts found, and it doesn't, most importantly, it doesn't address the standard of review under Rule 52A, which, excuse me, that findings of fact should not be set aside unless clearly erroneous, and due regard should be given to the opportunity of the trial court to judge the credibility of witnesses. It seems to be, and there are further expansions on that, such as in the Mancini case from last year by your court, that a finding is only clearly erroneous when there's no evidence to support it, or the reviewing court on the entire evidence is left with a definite and firm conviction that a mistake has been committed. And there are other related expansions on that. But and also as to the credibility of witnesses, that is a discretionary determination by the judge, and an appellate court doesn't disturb the trial court judge's discretionary ruling simply because the appellate court might have reached a different result. The standard of review is not substituted judgment. I'm quoting from Cruz versus Commonwealth. A judge's discretionary decision constitutes an abuse of discretion only where the appellate court concludes the judge made a clear error of judgment in weighing the factors relevant to the decision, and such that the decision falls outside the range of reasonable alternatives. Now, turning to the facts found by Judge Long below, as the court recognizes, the fence was originally made of wire, and according to the testimony of the Nannucci's witnesses, and it was replaced by the prior owner of the Nannucci's property with a sturdier wooden picket fence. This was testified to by Barbara McLeod, the daughter of the prior owner, and her brother Kenneth. Both testified as to the existence of the wire fence and later the wooden fence. Then there's testimony by Stephen Tabor, who was a tenant next door at the Pappas property from 1990 onward. And he testified that the wooden fence was put up in the following year, 1991, by Mrs. McLeod next door to protect Mr. Tabor's young children, who were about 1 or 2 years old, from the McLeod's dogs, and that the fence was put in the same place. And he knew because he did the landscaping while he lived there. So the wooden fence alone, and I think one of Your Honor alluded to this, the wooden fence alone was there for over 20 years. It was there for approximately 21 years. The issue of the permission to put up the wire fence previously purportedly from Mr. Papa to Kenny McLeod. Virginia Gardner's testimony about that placed it somewhere else in the yard at lot 51, and it was to contain a garden. And certainly that wire fence was containing the whole backyard of the McLeod's property. So perhaps there was some discussion about a separate wire enclosure for a garden, but it certainly wasn't something that was going to contain only, that was going to contain the backyard. And again, testimony from the McLeods was that the wire fence existed from the time they moved in the early 50s, and the Papa family didn't move in next door until the mid 60s. So they must have been talking about some other kind of wire enclosure. Concerning the grass area, within the fenced area, Kenny McLeod said that from a young age, he was responsible for mowing the lawn, raking the leaves, and so forth. Then in the front area that was bounded by the 3 trees, it was a line of trees. Clearly they were planted. They were equally spaced and in a straight line. And Kenny McLeod testified that he did the maintenance there, the raking, the mowing, and so forth. The only exception to that was testimony from George Gardner, the son-in-law of the Papas, who had a landscaping business at one time, and he testified that sometimes he would go around those trees onto the McLeod's side with his wheeled leaf blower, and he had to do that because otherwise there would have been a strip of leaves on their side of the trees. So to do a proper job, he had to go around to the McLeod side, but he said he only did that once or twice in November when he was doing the final cleanup for the fall. So that would just been a fleeting incursion, not any exercise of domain over the property, and he wasn't the owner either. So it was quite consistent that the McLeod family exclusively maintained both areas within the fence and bordered by the trees. So it was well within the trial judge's discretion to credit the testimony of the witnesses that the McLeod's fence existed for more than 20 years and that the area next to the trees was exclusively maintained by the McLeods for more than 20 years. There was some testimony from the Gardners that was equivocal or vague about the fence. One of them didn't remember the fence. One of them didn't remember when it might have gone in. That was George Gardner. So the trial judge was well within his authority to make credibility determinations and decide that the McLeods and Mr. Tabor presented credible testimony on the existence of the fence and also the maintenance of the property. So we urge the panel to affirm that portion of the judgment concerning adverse possession. Regarding the motion for involuntary dismissal, we've heard Mr. Lombardi's argument about the meaning of Chapter 260, Section 28, and that it operates as 1-year statute of limitations on recovery of land by an adverse possessor after being ejected, as the trial court noted, and in footnote 19, where Judge Sachs correctly pointed out that's really the meat of the judge's analysis, that the argument advanced by the Hynds is it's belied by the language of the statute and also the concepts of adverse possession, including that fee ownership vests in the adverse possessor after 20 years, and it's indefeasible, and it couldn't be defeated by a mere 1-year possession or a lawsuit by the record owner after the 20 years of possession by the adverse possessor. Now, our brief also delves into the history of that statute. It can be seen that when it's read together with the preceding sections, as it must be, it is part of a statutory scheme that sets out the controlling timeframes of adverse possession, beginning with Section 21 for recovery of land, and that is where the 20 years for adverse possession appears. And it talks about possession and entry. And entry, in my understanding, is an action by the record owner to recover possession from an adverse possessor.
Why,
Or-
and may I stop you there?
Yes.
If that understanding, when I read section 28, it seems to me that the he referred to in the statute is the person who was ousted, right? So claiming possession by virtue of something, but who was the object of the ouster. Do you agree with that?
I agree with that. And I,
All right, so then hold on. So why is it that then the person who needs to commence the action has to be the record owner? Why couldn't the person who was ousted have commenced the action?
well, as in this case, the adverse possessor commenced the action.
I thought you said that, right, so that's what my question is, because I thought you had just said that the action has to be commenced by the record owner.
Well, to go back, sections 21 through, it used to be 30, were adopted back in, I believe it was 1833, and it's based on prior British statutes. But in any case, it was a very discrete set of 7 or 8 sections dealing with recovery of land. Now it's been grafted into chapter 260, which contains most all of the statute of limitations for any kind of action. But, and as I put in our addendum to the brief, you can see how the statute, or the statute being those 8 sections together, always work together. And at one point they were in a separate section. But in any case, if you look at section 21, that provides the statute of limitations for the record owner to bring an action to recover from an adverse possessor. Section 22 is basically the tacking provision. There were some other sections that were repealed in 1979, and they had to do with legal infirmities such as underage, minority, mental disability, and so forth, but those were repealed. So that leaves us with section 28. So, and I think this is very clearly laid out in the materials in our addendum. Kasner's American Law of Property, the Iowa Law Review article, I believe the author was Taylor. Section 28 is not the rare bird that Attorney Lombardi would have it to be. It's very common. There are variations to it. Michigan and Hawaii have the same provision as Massachusetts. But in any case, those authorities make it very clear that what Section 28 and similar statutes applies to is what the record owner must do within the 20 years to regain possession and cut off the adverse possession. Now, it's, as has been said, this.
Well, then, may I ask you, then how do we understand the article he, not article, who does it refer to? Pronoun. Who does it refer to? I have trouble. What I hear you saying is that the action referred to in section 28 must be one brought by the record owner.
Correct.
Okay, then in the very last part of the section, then it must be that he refers to the record owner, and
Yeah.
that makes no sense to me. He was ousted or dispossessed.
He was ousted or dispossessed
By the adverse possessor.
Yes. And that's what Kasner and the Iowa.
Does tacking apply to that? Does tacking apply to that 1 year? To
Tacking
the
on.
calculation of that 1 year? So would it be 1 year from when he was first ousted or dispossessed? Because wouldn't that have to go back once the judge makes a finding of that the adverse possessor began possession 20 years ago? Would that mean that he needs to bring the action before year 19? Starts running?
Who are you referring to as bringing the action?
The record owner.
Record owner. Yes, the record owner has to bring it within 20 years.
Why? Oh, because you don't say there's actual disposition, being dispossessed until after the 20 years have run.
No, he's been dispossessed by the adverse possessor in year 1 of the 20 years. And in order to recover and be within the statute of limitations under section 21, he has to take possession or bring the action under section 28.
I mean, it seems to me if you look at the original statute, that the he has to be a person bringing suit for recovery of land. Now, I don't know in modern days, right, we have this odd situation where either party could bring this suit. And I don't know who's recovering land. On the one hand, there is the original record owner who in some sense was dispossessed 20 years ago or more under the findings of fact in any event. And then on the other hand, maybe the adverse possessor has been dispossessed, maybe by the record owner throwing the fence away and saying this is ours. So I don't know. I mean, to me, at the end of the day, the or sort of, in each case, it seems the person who entered on the land in both cases was there for more than a year. So I don't really see what difference this clause makes because of the or. As for tacking, it looked to me like under the original statute, the cause of action itself talks about the person, the rights of the person, or the rights of the person under whose claim they are recovering or something. I mean, I don't know. It doesn't seem like an accident that no one's construed this. It seems, I don't even know when it applies anymore, so.
Well, it does appear to have been displaced or forgotten, and the common law of adverse possession has really supplanted it. But I would say that the record owner coming in after the 20 years, the only way that they can get title is by their own 20 years of possession, because adverse possession vests title in the adverse possessor.
All right, so your time has expired, though there may be questions on this, no? Everyone's happy? All right, thank you very much. Excellent and interesting arguments. The case is submitted.
Thank you, Your Honor.
And that concludes our sitting for today.